Thank you, colleagues. Today we're continuing our pre-study of Bill C-15, which is currently at second reading in the House of Commons. We've received an order of reference authorizing the committee to examine and report on the subject matter of the elements in Divisions 4, 9 to 17, 22, 23, 37, 43, and 45 of Part 5 of the bill, an act to amend certain provisions of the budget tabled in Parliament on November 4th, 2025. Today's meeting will be divided into 3 panels. We'll start with 60 minutes with the senior officials from the Office of the Privacy Commissioner of Canada. Welcome. We have Philippe Dufresne, Privacy Commissioner of Canada, and Marc Chenier, Deputy Commissioner and Senior General Counsel. We also have senior officials from the Competition Bureau of Canada with us this morning. So Anthony Durocher, Josephine Palumbo, and Mr. Matthew Chesson. I understand that some of you may have very short opening statements to make, after which the senators will ask their questions. Now, should we do the opening remarks all at once, or should we go division by division? I'm not sure what you think, colleagues. Maybe I can ask for the representatives from the Privacy Commission to speak first, and then we'll do questions, and then we can continue. I'll ask Mr. Dufresne and Mr. Chenier to make any opening remarks they have. Thank you, Chair. Thank you for the invitation to appear before you today to offer my views on the privacy implications of Part 5, Division 23 of Bill C-15, Budget 2025 Implementation Act Number 1. As was mentioned, I am with Marc Chenier, Deputy Commissioner and Senior General Counsel this morning. I'll limit my remarks to the proposed amendments to the Personal Information Protection and Electronic Documents Act, or PIPDA, which provides for a right to data mobility to facilitate information sharing across all economic sectors.
Bill's policy objectives and the importance of the right to data mobility in today's digital economy. Data mobility would give Canadians greater control of their personal information by allowing them to make decisions about who they want their information shared with. This would make it easier for them to switch service providers and choose which organizations they want to engage with. It would also help promote competition and innovation by allowing individuals to take advantage of new business models like consumer-driven banking and encourage new players in the market, thereby helping support small and medium-sized organizations. Allowing individuals to control where their information is going helps to build trust in today's data-driven economy. For this reason, I support efforts to introduce a right to data mobility in PIPDA, a right that already exists in many jurisdictions around the world. Specifically, Bill C-15 would add a new Division 1.2 to PIPDA that would require an organization, upon an individual's request, to disclose the personal information that it has collected from them to a designated organization. This right would be subject to regulations and would only apply if both organizations are subject to a data mobility framework. PIPDA would also be amended to provide the Governor and Council with powers to make regulations on data mobility frameworks, standards for safeguards, and matters related to interoperability. Étant donné que de nombreux aspects du
As many aspects of the data mobility framework would be clarified in the regulations, including those related to standards, safeguards, and interoperability, it will be important for my office to be consulted by the government in the development of those regulations. Thank you, and I would be pleased to answer your questions. Thank you. I think it would be easier for the discussion if we move immediately to questions on this division. And I would ask you to limit your questions to 2 minutes per person. After that, we'll move on to the Competition Bureau. And then after that, we might have time for questions for anyone. I'll start on my right, Senator Marshall.
Thank you for being here this morning. You mentioned that you looked at Division 23, and by your speech, you're giving the impression that you don't have any problems with it, but you did mention the fact that you haven't seen the regulations yet, and the devil's in the details. Can you just give us, from a general perspective, how you review the legislation, and what type of people do you have working in your office? Like, how much detail? Like, it sounds good on paper, but maybe in actual fact, maybe it's not going to be as good as what we think it's going to be. So I'd be interested, you know, like our personal information is everywhere in the banks, is in the healthcare boards. So what sort of review do you do in order to come to the conclusion that, you know, you don't have any problems with Division 23, and whether, you know, you're going to have any concerns with the regulations? Just looking for some reassurance as to the depth of your review.
Thank you. So we look at all pieces of legislation with potential privacy implications, whether it be in this context or whether it be national security. As you rightly point out, privacy touches so many fields in our world. And this is why we are working in my office more and more closely with other regulators. And the theme of cross-regulatory collaboration is extremely important. We, in fact, have created...
Sorry to interrupt. We have a technical problem, so the clerk asked me to suspend for just 1 minute to fix that.
Privacy is linked to many, many areas: competition, broadcasting, national security. So we've actually created in Canada the Canadian Digital Regulators Forum, which includes my office, the Competition Bureau, the CRTC, the Copyright Board. So we work very carefully together, and we look at pieces of legislation to see what are the impacts in our respective areas. So in this case, we look at these provisions to see will privacy be protected? Will there be safeguards? Will there be a right for organizations to properly give their consent? Will the information be treated appropriately? And so a lot of that here will be done in the regulations in terms of safeguarding, in terms of which organization. So what I'm saying is it will be important, if not essential, for my office to be consulted in the drafting of those regulations. And we do that in other areas in the context of banking, sharing information with each other to prevent fraud and terrorism financing, for example.
Thank you, Senator. We'll go in second round because I tried to limit. It's not easy this morning. Sorry about that, Senator Martin.
Okay, thank you. I'm going to just, I might only have time for one question, but it's regarding the safeguards themselves. I know the regulations are forthcoming, but from a privacy perspective, like what specific safeguards need to be in place before this new data mobility right is activated? And then how would these safeguards reduce the risk that Canadians' financial and other personal information is exposed or leaked as it moves between organizations?
We need to make sure that the information is disclosed in a secure way. So how will the information be protected? How will the consent be confirmed? What protections will be put in place to avoid privacy breaches, personal information being disclosed inadvertently? How will this be managed in terms of the parameters for technical means to ensure interoperability and collection? So this needs to be seamless. It needs to be user-friendly. It needs to be secure. Canadians need to have trust that their personal information is going to be protected. And so that's what we see in other countries. For example, in Australia, the privacy regulator, my colleagues, they are directly consulted in the drafting of regulation for comparable provisions. And so this is an area where it touches economic aspects, banking aspects, but there is a privacy aspect because you're talking about personal financial information of Canadians. And so our involvement in that process is going to be extremely important.
Thank you, Senator. So maybe second round. So Senator Deakin.
Thank you very much, Chair, and thanks to all of you for being with us. I'm going to ask a question. I'm going to break your rule and ask a question of both because this is the competition and privacy are so closely linked in our digital world. Commissioner Dufresne, have you been approached by any other departments who would also like to give Canadians safe and secure access to their data in other areas? Has any other department come to you and said, we want to know how to do this, it's being done for open banking?
Well, we've been working, for instance, with the Department of Finance in the last Parliament leading up to the PCML-TFA amendment, so to fight money laundering, terrorism financing, and we've established codes of practice. Other areas, specific areas, we've not been engaged, to my knowledge, in terms of additional sharing of information.
Thank you, Commissioner Dufresne. So just to the Bureau, how important is it that we look at data rights, data privacy, data security?
Because I have done that by purpose, but at the end we will have a chance that both will be answered to your question, if you don't mind. Hoping not to be rude, but it's just that I try to be coherent, if you want to, consistent. Go ahead, Senatrice.
Thank you, Chair. I understand what's your responsibility and so forth. However, if within this framework that our personal information resides outside the country, you have no jurisdiction. So how will this be managed to provide a sense of security for financial information to consumers?
So there are a few ways where this could be done. One, this could be provided for in the regulations in terms of particular processes if the information is going to leave the country. That's one area. Another area, and this is something I've recommended, is to amend privacy law generally and to deal with the issue of cross-border sharing of data, to make sure right now we have a requirement that by contract or otherwise you have to have similar protections. But there may need to be more than that in terms of privacy impact assessments or greater safeguards if data is going to be going in other countries, because you're right, we can't control what other governments are going to do, but we can set parameters and expectations and review processes. So that could be done in regulations, could be done in law reform for privacy.
Second one, I understand you. Okay.
Okay, thank you, colleague, for your understanding this morning. My colleague, Senator McBean.
Thank you. Just more broadly, how will data mobility be defined, and which organizations are going to be subject to it?
Well, this will be defined in the regulation. So the section 10.5, 10.6 talk about the regulation will be specifying the organizations that are subject to data mobility frameworks, and also the regulations may distinguish among different classes of activities, information, or organizations. So it may not be a one-size-fits-all. You might have different provisions for different sectors. My understanding is that the goal is for the banking sector to be the first with the open banking, but there may be different sectors, and then it's not a given. Again, that's going to be up to the Governor and Council, hopefully with our input, looking at what are the different types of rules that can apply. And then that ideally you have a nimble system that's flexible enough, that's tailored enough, but we need to make sure that privacy is protected always.
Are you, as Senator Marshall said, the devil can be in the details. Are you at all concerned you're like ideally, and it's coming down like in a privacy framework? Are you, do you have any like red flags or yellow flags about how the system's going to be created?
Well, I am setting out my expectations publicly that the government will consult my office in doing that. We'll be reaching out to them if Parliament adopts this legislation to establish those links. I will presume that the government will be open to doing this. If they're not, I will certainly raise it at that time.
Please do. Thank you.
Thank you, Senator. Senator Youssef.
Thank you, Chair, and Mr. Frank, thank you for being here. And thank you for the work you do on behalf of the country. My question is more specific. I understand what you want to see safeguarded, but despite your best intentions, there are going to be breaches. When the breaches happen, what are the penalties for those who breach that? Because we have to ensure, because we're seeing this more frequently, systems are being hacked and the consumers are left to say, oh, sorry, we didn't know, you know, you're supposed to now figure it out. Well, you can't figure it out. It's my personal data and financial data. Have far more dramatic impact on people's life, especially gets into the wrong hands and criminals are but it's not just in this country but throughout the world. So what are the penalties that we should have imposed when the regulation is drafted that will ensure that those who are responsible know there are obligations and there's stiff penalties if they don't follow the regulation.
Well, in terms of open banking, the bill talks about liability aspects and holding the banks liable for the cost and the impact. So that's dealt with there. From a privacy perspective, you've identified a big gap in the current legislation. We need to have stronger financial consequences. Right now, I do not have the authority to issue orders or financial consequences for privacy breaches. So that was made evident last year. Joint investigation with the United Kingdom, they issued $1 million or so such penalty to 23andMe, and I could not. So I have been calling for law reform in that sense. I am optimistic that this will be coming, and that will be very important to strengthen the legal regime.
Thank you.
Merci, Sénateur. So, Sénatrice Henkel.
Merci, Monsieur le Président. Bienvenue parmi nous.
Thank you, Chair. The bill would ensure that entities remain responsible even when they're outsourcing to a third party. But there are often 4 or 5 layers of subcontracting, and sometimes those companies are foreign. So how can your institution really audit those complex chains of power and resources? And do you have the resources you need to carry out that responsibility?
C'est clair qu'on doit.
Thank you for the question. It's clear that we need to strengthen the current legal framework. As I said, I don't currently have the power to emit financial penalties, and the data sharing framework outside of Canada is not as rigorous as it could be or should be. So I hope that there will be legislative amendments to that effect. In the meantime, to face this challenge, I am working very closely with my colleagues and my international counterparts. No country can deal with this alone, and Canada is no exception to that. There is a strong community of privacy commissioners, including in Asia, in Europe, and all around the world. This year, I was elected chair of the Global Commission for Privacy Commissioners, and so that really puts Canada in a leading role on this front in terms of developing policies and recommendations. Thank you for that appointment. I think that's a great honor to Canada. Thank you.
Senator Lefredo.
Senator Lefredo. Thank you, Chair.
Morning. Mr. Dufresne, my question, well, maybe you can elaborate on the most significant gaps that Parliament should address. And more precisely, my question is on data minimization rules. I mean, the Personal Information Protection and Electronic Documents Act is built on consent. But consent in today's digital financial environment is often broad, bundled, not fully understood by consumers. And do the amendments in Division 23 improve the quality, transparency, and meaningfulness of consent? And if not, where should Parliament go? And to wrap it up, I mean, we have open banking, real-time payments, increased connectivity. Should the government consider further data minimization rules for consumer protection?
Thank you for the question, and I think data minimization, in particular with respect to personal data, is key. And you're right to highlight it, and we need to continue to highlight it. We need stronger provisions there. It's difficult for Canadians, for anybody, even experts, to consent, to understand the complexity of all of those provisions. So a positive step, for example, in the open banking bill here, we're talking about consent being simple, understandable, meaningful. So these types of strengthening for consent is important. There's room to do that in the regulations in this section. And we need to do more about that in global law reform to make sure that consent is clear, easy, user-friendly, and otherwise that there is this sense of necessity and proportionality. And to give an example, we did an international sweep with competition authorities and human privacy authorities looking at websites and apps to see if they were using deceptive design practices. So tools and psychological tricks that make it harder to understand what's going on and to make it harder to protect your privacy. And we found that this was used across the board. So complex policies, nudging techniques, and so on. So we really need to continue to push against that and to say, let's make it easy for Canadians to understand and to protect their privacy.
Thank you. You spoke about your concerns about sanctions, your capacity to sanction. In these amendments to the Act, everything's deferred to the regulations, which gives parliamentarians very little direct oversight. Are there items, aside from sanctions and whether they could be integrated in this, that should be in the framework of the legislation itself as opposed to the regulations?
In the context of this specific legislation, the only area, which again doesn't need to be in the bill itself, but it should be an expectation and understood, is that the privacy regulator is consulted in the development of those regulations. More broadly, we need to look at law reform for privacy legislation in the private sector and in the public sector, because this new regime is made subject to my authority to review and to receive complaints. So it's going to be impacted by the overall privacy regime. And that overall regime needs to be improved to have a stronger recognition of privacy as a fundamental right, stronger recognition of the importance of children's privacy, stronger enforcement mechanism. And also a key point is the ability for my office to collaborate more broadly with other regulators. I mentioned that we are doing it already in Canada with the Competition Bureau, with the CRTC, as much as we can. But there are limits to that. For instance, I don't have the authority to collaborate in terms of investigations. I have the ability to collaborate in terms of guidance and overall policy, but not to investigate. I can do that more easily with the U.S. Federal Trade Commission than I can with the Canadian Competition Bureau, which is an obvious gap. So in this world where we're going to be giving more powers to the Bank of Canada, where there's going to be financial regulators, a general proposition should be that my office has the power and the mandate to collaborate with any regulator whose mandate dovetails on privacy.
J'irai au sénateur Dalphond, après quoi je vais offrir la parole à
Senator Dalphond, and then I'll give the floor to Senator Papatello, who's the sponsor. Thank you, Chair. So people could make a complaint to you. You would report on the complaint. But then if there's no follow-up to the complaint, the person could go to the courts. But you would not go to the courts on behalf of that person. They would have to hire a lawyer and carry that burden. Is that correct? I could also bring the case before the court in certain cases, but the challenge is that would be a de novo process. So independently of the process that my office made, we would have to start from square one with the complaint. So that's long and costly. That's why one of the main recommendations, which is not made here, but that I hope will be brought forward shortly, would be giving my office the power to emit penalties and orders. Then, of course, there can be a judicial review, as you know, but under the current system, it's too slow. So a decision is made, but then nothing happens before the federal court actually makes its ruling. So that's very slow. A concrete example, if you look at the case involving Pornhub, there were insufficient protections and so images for which there was no consent were actually published online. It's a terrible situation. And currently it's before the federal court because the organization refused to follow my recommendations. So it creates a lot of delays, and this means that victims continue to suffer for a longer time. Thank you. We'll move to Senator Papatello. Do you have a question?
Thank you. Two questions. One is around data storage and the localization of data storage within our country, and as it relates to open banking, or if you have a position, it's mentioned in the budget in terms of assisting in funding of that. But do you have a position generally around where it's stored and as it relates to open banking in particular? And my second question is what role your office has in the financial literacy piece that Bank of Canada is maintaining and would continue, and in particular, the areas around privacy that the public should be aware of. Do you participate in the delivery of the public education piece?
Thank you. So in terms of data localization, it's certainly the more things are in Canada, the more power that we have over it, the easier it is to apply Canadian law. Now, if things are happening in other countries, but it's impacting Canadians, we will still have jurisdiction, but it raises different types of challenges in terms of enforcement of those decisions. So this is why we need to have a regime. And that could be done through those regulations. It could be done through law reform of the Privacy Act to make sure that if data is leaving, there's a framework. Doesn't mean that data can never leave Canada because that would harm intercommercial international trade. But certain types of data, you might need stronger safeguards. In terms of the education and financial literacy, I don't believe that we are currently doing work with the Bank of Canada on this, but I see this as an area where we should be doing it if the bank is going to be taking on a role in the open banking. And we have a general mandate to promote privacy. And as indicated at the outset, privacy is being impacted more and more by other domains. So the cross-regulatory collaboration is increasing both here at home and internationally, and we're playing an increasingly greater role on that, and I can see this specific example as one where we'll want to be involved.
So what I propose, colleagues, I will offer the opportunity to the Competition Bureau to, in fact, provide the opening remark, go with the first round. They will have enough airtime in their case. I will be fair for both. And we'll have a second round at the end, if it's possible. So I will invite, Madame Polambo, CHA on Rocher for your opening remarks, and welcome here.
Bonjour, Monsieur le Président et honorables sénatrices et
Good morning,
sénateurs.
Chair and honorable senators. Thank you for welcoming us this morning. My name is Mathieu Chasson. I am a senior policy advisor at the Competition Bureau. I'm joined today by my colleagues Anthony Durocher, Deputy Commissioner of our Competition Promotion Branch, and Josephine Palumbo, Deputy Commissioner of our Deceptive Marketing Practices Directorate.
It's critical to building a stronger, more affordable economy. Budget 2025 contains a set of competition-related measures which are described in the budget as early but meaningful steps to increase competition and drive down costs in key sectors, with more to come. The government has also indicated that it intends to be hawkish on competition, with all parts of government involved. Needless to say, we strongly support this direction. You have invited us to speak specifically about Divisions 9 and 43 of Bill C-15, which are the changes related to the Consumer-Driven Banking Act and to some of the greenwashing provisions contained in the Competition Act, respectively. I'll briefly address each of these in turn. First, with respect to consumer-driven banking, sometimes called open banking, the proposed reforms are consistent with the Bureau's long-standing advice. They will strengthen competition and innovation in our financial sector by creating a framework within which consumers can safely and securely share their data. This will make it easier for consumers to switch providers and access new, innovative services, which means that banks will have to work harder to keep customers happy. You will see that competition considerations are expressly hardwired into this legislation, in the Purpose Clause, in the Bank of Canada's listed objectives as the regulator, and in various aspects of the regime. Of course, many details will be set out in follow-on regulation, and the Bureau will continue to provide independent competition advice as needed to support the rollout of this important framework. Second, with respect to the greenwashing provisions in the bill, we understand that the proposed changes are intended to provide more certainty to the marketplace while maintaining protections against false or misleading environmental claims. If these changes become law, businesses making environmental claims will still need to be able to back them up with adequate and proper substantiation, but this substantiation will no longer need to be based specifically on an internationally recognized methodology. If these changes come into effect, we will update our guidelines accordingly. The changes also remove the ability of third parties to bring greenwashing complaints directly to our competition tribunal under this amended greenwashing provision. However, they can still bring such claims under other deceptive marketing provisions with different tests. Avant de répondre à vos questions, je tiens à préciser que la loi...
Before taking your questions, I would note that the law requires the Bureau to conduct its investigations in private and to keep confidential the information that we have. This obligation may prevent us from discussing certain facets of our investigations or even the existence of certain investigations. Thank you, and we look forward to your questions. Thank you, Mr. Chasson. So, colleagues, I will thank you for your understanding this morning because we have a very busy schedule. So I would ask you to limit yourselves to one or two questions, no more than 2 minutes, and we'll start with Senator Dalphond. Thank you, Chair. Welcome. I'll go directly to Section 43, the amendment to the Competition Act. I understand that the Senate was heard from on these amendments because I believe a year and a half ago we recommended that you remove any reference to international standards because many witnesses had told us about their concerns that certain standards about, the quality of aluminum or iron, which were sometimes set by other countries, were problematic. And we wanted to have standards here in Canada. So I believe that we were heard. You heard our recommendation. Yes, thank you. That's correct. I just wanted to thank you, I guess, for following up on a report. That's it. Thank you. Thank you. It's nice to know the Senate actually plays a role of sober second thought. I guess we're doing a little bit of PR for ourselves this morning. So we'll go to Senator Pipitello, and then I believe you're the sponsor of the bill, so you can ask any questions afterwards, and then we'll move to Senator Friedhandler.
Controversy in the marketplace. I'd like your comments on the general necessity and based on the fact that we have disclosure law under provincial securities acts that relate to companies and create liability frameworks generally, why we need another layer of regulation here?
So I'll allow my colleague Josephine Palumbo to respond to that, but maybe just to clarify for the previous senator that these changes were adopted by ISED. I understand you'll be speaking to ISED policy officials. We're really the enforcer, so we come at it from the enforcement perspective, but Josephine, please.
Yeah, so let me just start by saying that our mandate is to administer and to enforce the law as enacted by Parliament. So that's our job. We don't set policy, we don't draft legislation, but we're always committed to a transparent, principled, and evidence-based enforcement approach under the Act. With respect to securities legislation, we understand, of course, that securities registrations exist and disclosure obligations exist, but our concern does not focus on those provincial requirements for disclosures. Our focus is on false or misleading representations in the marketplace. So while yes, securities regulators do require a certain degree of disclosures for purposes of their provincial regimes, our concern is focused on discouraging companies from making representations to the public that are false and misleading, and in this case, with respect to environmental claims and the benefits that may or may not exist to consumers.
Merci, Monsieur le Président. Thank you for being here once again. On new powers and enforcement, Division 43 appears to enhance the FCAC's powers, including compliance, supervision, and potential penalties. Are these powers sufficiently strong to ensure banks and fintechs meet their obligations under the new consumer-driven finance environment? Do you require additional order-making authority? And how will you coordinate with the OSFI, FinTrack, and Privacy Commissioner to avoid regulatory gaps in a system where one consumer transaction, only one, may touch multiple entities?
Thank you for the question, Senator. I'm not sure. Maybe that might be a question for our colleagues at the Financial Consumer Agency of Canada. The provisions in this bill don't modify any of the penalties that the Competition Bureau can impose, but they do provide some measures for ensuring compliance with the Consumer-Driven Banking Act. And from what we can tell, from our distance, they appear to be appropriate ones to ensure that these provisions are complied with.
Thank you.
Sénatrice Simcoe? Non, pas de question. J'ai omis de souligner la présence de...
No question? Okay, I forgot to mention that Senator Yuans is now with us. I believe you're replacing our vice chair, Senator Veroni. Welcome. I don't know if you have a question to ask? No? Not at the moment. Okay. Senator Youssef.
Briefly, one of the arguments the government laid out in regard to making the change necessary here is to try to deter what is called chill effect, to people launching complaint frivolously to create havoc. Could you give me an example of that?
So this is with respect to the environmental piece. So again, if what the framework under the current legislation would impose on businesses to demonstrate their substantiation with internationally recognized methodologies, then we get into a debate about what is an internationally recognized methodology. We took a position in our guidelines that where we had 2 or more countries that recognized a methodology, we would consider that. We could consider that as substantiation, valid substantiation. Without this requirement, what happens is businesses will have a lot more flexibility to bring forward how they establish adequate and proper substantiation. There's no longer that limitation or that measure. And so that will allow that flexibility for businesses to support and show support for their claims with respect to environmental protections.
Do you have a list of countries which you will use as your methodology to compare with?
So we no longer, again, we through our guidelines, we established that we would be looking at a list of countries, 2 or more, whichever they be, and then we would have assessed under that legislation. And again, when we're looking at those 2 or more countries that would be recognized as valid methodologies, it wouldn't necessarily be the actual countries that we would be looking at. We could also look at things like standard-setting bodies in those countries, regulatory authorities, or industries, so we wouldn't have been limited. Now, without that measure of substantiation, as I said, you have a lot more flexibility. We also have a lot more flexibility in terms of what will qualify for substantiation. It could be a nationally recognized methodology, it could be a municipal standard methodology, and we could also perhaps consider international standards as well. But we now have that flexibility to do that.
Okay, thank you. Thank you.
Senatrice McBean.
Thank you. In the same vein, so I understand from Senator Delphine, we're happy to have a more made in Canada solution to this. So we don't have to be looking for the internationally recognized methodologies. But now, how is the government going to ensure that the environmental claims remain credible?
Prior to the implementation of these 2 provisions, the new provisions that were passed last year in June, we had false or misleading provisions within our Act that were general in nature, so that would allow for the agency to review representations with respect to environmental claims. And in fact, we were active in this space. We engaged in 2, in particular, publicly known businesses, the Keurig case, which was a recyclability of K-Cup pods and whether or not they could be, in fact, recyclable across Canada. And our investigation proved that no, they could not be recyclable other than in British Columbia and Quebec. So the company had to make changes to their labeling and ensure that consumers knew the reality. And that's what this is all about. In my directorate, we focus on truth in advertising. That's what we want. We want Canadians to know the facts so that they can make informed decisions. The other case was the Volkswagen case dealing with the emissions testing. And both of those cases fell under the old or the general false or misleading regime. So we have the law. We will continue to apply that law, but we now also have the benefit of these 2 specific additional provisions that we might consider applying as we analyze our investigations and complaints that come to us.
Thank you, Senator. Senatrice Ringuette.
Pour la deuxième ronde.
Okay.
For the second round. Okay. Senator Deakin.
So, thank you, Chair. Just to build off of my question to Commissioner Dufresne, because of the close link in a digital society between competition and privacy, and focused on Division 9 and on 23, can you just Canadians need safe, secure, and value-added access to their data in a number of areas. I'm disappointed that there's no department sort of saying, hey, can we get this for consumers in the areas that our departments are involved? But that's not surprising, but disappointing. Can you explain the importance of the Competition Bureau's involvement in developing regulations around issues that really involve data privacy and the use of data in marketplaces in Canada?
For that question, I mean, I'd echo something Commissioner Dufresne spoke about in his remarks. Consumer trust is key, and for us, it's a key component of an open banking framework or an open data framework. If there's not the consumer trust that their privacy will be protected, that fraud risk will be dealt with, there won't be adoption, and if there's not adoption, we're not going to see the competitive and innovative benefits that we are hoping to see from these frameworks. So I think we are totally aligned. They're, of course, the experts in how best to ensure those privacy issues are dealt with. So we defer to them on that, but we totally support those efforts. Privacy issues can be competition issues, and competition issues can turn into privacy issues. So it's absolutely critical that we work together. We have the Canadian Digital Regulators Forum. We have other fora where we collaborate with one another, and it's critical that continues.
And just a quick follow-up, thank you. From a legislative drafting standpoint, do you find that you are being brought in early enough to make sure that we're shaping our legislation in a way that allows for this opportunity, which is so central to Canadians having safe, secure, and value-added access to their data? Are you brought in early enough, or do you have recommendations for us or observations for us in that regard?
Senator, I can say that it's getting better.
Well, you were a lonely group for a long time, and that's right. To Canada's deficit.
I mean, I think I mentioned in my opening remarks, the government is setting the tone in terms of wanting to focus on competition, and I think we're seeing now, if I could describe it, excess demand for the Bureau's input, and it's coming earlier. So that's very, very much a positive from our point of view. We can influence things a bit more when we're on the front end than on the back. So I think it's the start of maybe something, and we're excited about it.
That's great news. Thank you, Chair.
Happy to hear that government listening, and thank you for your leadership, Senator Deacon. You have a very credible voice around the table on that. Senator Marshall.
Yes, thank you very much, Mr. Chair, and thank you very much for being here this morning. With regard to Division 9, the consumer-driven banking, now we're not there yet. We've still got a ways to go. But you were saying earlier in your remarks, you're considered an enforcer. So you have this legislation. We don't have the regs yet. So how are you preparing for your enforcement? Can you just give us some idea as to what you're doing in preparation for?
So just to be clear, with respect to consumer-driven banking, enforcement responsibilities will rest with the Bank of Canada. We're still in the picture as the Competition Bureau under our general law, but this is a fairly self-contained piece of legislation that sets out the do's and don'ts, and if there are contraventions, it's for the Bank of Canada to enforce those. In our role in this is more of an advocate, helping them design and craft those regulations in a competition-friendly way, providing our input into that. And there will be regulations that will flow from this, and I think what we find encouraging is that the primary legislation hardwires some competition considerations into it. So as they go to develop their regulations, they're going to want to do that consistent with the purpose of this act, which recognizes competition. So,
do you already have a relationship with the Bank of Canada with regard to this legislation?
I don't think there's a formal statutory relationship contemplated, but we do have a relationship and close colleagues that work there, and we will work with them.
Okay. Can I ask one quick question?
Be a good one.
Okay.
If you don't mind. Senator Martin.
Yes, thank you. So my question is related to the Act being amended to prevent private parties, other than the Commissioner of Competition, from initiating competition tribunal proceedings regarding environmental claims. So just, are there any concerns that removing private access could leave legitimate complaints from smaller market players without an effective remedy? And what sort of safeguards would be in place to ensure effective oversight and accountability if private parties can no longer bring it to the tribunal?
Thank
Thank you very much, Mr. Chair, and thank you for the question, Senator. To date, we have no greenwashing private action that has been launched before the Competition Tribunal, so there is none that have been initiated to date. There are other options. So we don't see this as an obstacle in the sense that smaller organizations can still register a complaint with the Competition Bureau, so we can still initiate investigations through the agency itself under our Section 9 provision, which is a 6-resident complaint process and which compels the commissioner to begin a formal inquiry. They could also file private action under the other provisions. So it's just B.2 that has been is being proposed to be removed from private access. But parties can still apply for private access under the other provisions that I enumerated earlier in my presentation. So there's still options available to ensure that people's rights are being heard.
Colleagues, we have been very efficient. So we have now a possibility to have a second round. We have 10 minutes left, but I have to make a little survey. How many want to intervene? Okay, they can, 3, 4. Okay, so what I propose is maybe since we are 3 senators who want to intervene in the second round, okay, so maybe 3 minutes each. So starting with you, Senator Marshall.
I'll need 3 minutes, but look, this is for the Competition Bureau. I was kind of surprised in your opening remarks. You said, you were here to speak at Division 9 and Division 43. Would you not have looked at Division 17, the section about supporting federal credit union growth? Would that not be an area that would be of interest to you?
Well, thank you for that question. I think we were just referring to the sections we were invited to speak to,
okay.
But no, we were aware of that as well, and I believe that falls under FINES's responsibility. It really does not alter the role that the Competition Bureau would play in
as enforcer?
As an enforcer of the competition law in respective credit union issues.
Okay, so you do have a role and you are aware of that section?
Yes.
Okay, thank you very much. Thank you.
Thank you, Santos.
Thank you, Chair. Just as we look forward to regulation of open banking, but we're also seeing the same body will be responsible for retail payments and stablecoins, which actually we got some really good information from the Senior Deputy Governor when the Governor and Senior Deputy were here, that they're really looking to streamline that process because many of the same entities will be involved in all 3 areas. So do you have concerns or thoughts or advice as it relates to that new regulatory capacity at the bank? I think that many of us are very confident that they're comfortable with the fact that they're in that position, but regulating 3 new areas that are so central to the financial security and access to efficient financial services for Canadians. So maybe start with you, Commissioner Dufresne, and go to the Bureau.
I think that I share your confidence in their ability, certainly, but I would say that insofar as it touches upon new areas like data protection and privacy, that's where that increased collaboration with other regulators like my office becomes important, and so we will certainly stand ready to assist them and to collaborate with them as appropriate.
Thank you very much.
I think that would be a good question to ask the bank. I think if we speak from our perspective, they are absolutely revered as an economic regulator in Canada. They move mountains with the resources they have, but if they say they need more, then that should be considered.
So it's, from your standpoint, you stand ready to help them to make sure that the systems are implemented in a way that is pro-competitive.
Absolutely.
Yeah, and privacy protective. So thank you very much.
You have time for another question if you want.
I'll leave it for now.
You want, okay, Senatrice Ringuet.
A few short questions.
Yeah, you have time.
Okay,
So we have
thank you.
at least 5.
Monsieur Dufresne, the issue that this piece of legislation does not give you authority in regards to penalties is of concern, because I don't see how you can introduce through regulation the mechanism of penalty at your office. Am I correct in my assumption?
You are correct. So this would require law reform of the privacy legislation as a whole. The Minister of Artificial Intelligence, Minister Solomon, has stated that they are working on a piece of legislation to modernize privacy law. And so I will look forward to seeing that. And I have publicly stated that my expectation is that any law reform will include powers for my office to issue orders and fines.
Being said, and this committee for many years have voiced their concern in regards to the current charter banks in Canada and the fact that financial data, consumer financial data, does not reside in this country. And that is a serious threat, and we've seen, I think, like 2 or 3 years ago, where there was a major breach of a credit evaluator, and still we don't have in the legislation, okay, penalties and your oversight. So what's happening? Like, this is a brand new framework that's still not in place, and they're looking at, giving you some authority and so forth. And we have this old system that we've been complaining about, and there's still no mechanism. So how can we move this further, because it's desperately needed and has been needed for years?
Absolutely. Well, the most important step is what Parliament can do in amending privacy law. So that's a given. In the meantime, I am using all of the tools at my disposal. Of course, I cannot make law. I can give input on regulations and work with the government there. But what I am doing is working very strongly within Canada and outside Canada to leverage the collective power. So, for example, I did a joint investigation with my colleagues from the UK. They have order-making powers. They have fine-making powers. So working with them, we did a joint investigation of the 23andMe breach, and we were able to have joint findings, which included a fine because they have that power. We're working with the international community to build cross-border data rules. We're working with OECD to call on governments to respect the rule of law. So I'm going to use all the tools that I have, including promotion, but at the end of the day, Parliament needs to make the decision to give my office these powers so that the real concrete impacts can be delivered.
Merci, sénatrice. J'ai le sénateur Frédéric qui voulait intervenir et je reviens à vous si on...
Thank you. I'll come back to you after, but I just wanted to thank you on behalf of the committee for giving us so much detail about this important subject. And thank you, Mr. Dufresne. I know that you have all of these tools at your disposal to tell the government what you expect, and I appreciate that. Now, this is a pre-study, and that gives us the opportunity to really have an influence on the government and push them to amend the bill if necessary. So, Mr. Dufresne, maybe you could provide us with a written answer. I don't follow everything you do from day to day, but maybe just a summary of the most relevant information that you think the committee should have. And references to the international situation as well would help us. And we will be able to make observations in our report on this study. I'll go briefly to Senator Lefreda.
Dufresne.
For Mr. Dufresne.
Financial regulation and sometimes consumer protection rules, even when well-intentioned, can unintentionally create anti-competitive outcomes. From a competitive standpoint, do stronger consumer protection rules enhance market efficiency, or could inconsistent enforcement create distortions? And how do we mitigate that? Do you foresee areas where competition concerns may arise directly from consumer protection enforcement?
Thank you. They can, and this is why we need to work together to make sure that we manage them and avoid them. This was one of the reasons why we created the Canadian Digital Regulators Forum, so that I'm not protecting privacy at the expense of competition and vice versa, so that we can identify those issues. So we've done work on synthetic media, deepfakes, to see what are the privacy aspects, what are the competition aspects, things like algorithmic pricing, things, are you going to use privacy to take out competitors? How do we make sure that we're reinforcing privacy, we're reinforcing competition? And one of the first statements I made as commissioner was to say that privacy is a fundamental right, but it is also very much consistent with the public interest, with innovation, with a strong economy. So we cannot put Canadians in a situation where they have to choose between strong competition and strong privacy. They're entitled to both, they can have both, and that requires that collaboration, which we're doing here in Canada and around the world.
Thank you. Merci.
Collègues, on se donne 5 minutes maximum de plus. Donc,
Colleagues, we have at most 5 minutes left. Senator Henkel? Yes, thank you, Chair. And thank you for having asked for that information, Chair, because that's what I was going to ask as well. You know the subject much better than we do, and so I have 2 quick questions. The first is that I'm convinced that you have already raised the fact that the government should be significantly stronger, vis-a-vis Meta and so on, as the European Union, Australia, the UK are already doing. Perhaps in just a few seconds you can tell me what you were told. What does the government say is the major challenge to reacting, whereas other G7 countries have? What I would say is that the government tabled C27 in the last sitting, but it died on the order paper. The Minister of AI stated publicly that he is working on a new version of it and that it would be going forward soon. So I continue to encourage them to do so. I think that will strengthen Canada's hand. In the meantime, I'm continuing to use the tools that I have. We're currently in front of the Supreme Court of Canada on a case involving Facebook and consent and protection of privacy. So this is something Parliament can work on as well. And in terms of the international community, we've made statements. I chaired the Commission of Privacy Commissioners this summer, and we issued a statement about protecting privacy from the very beginning of new initiatives and, starting with children. So we do this in a number of ways, and I hope that Parliament will also take legislative steps soon.
je pense 3 interventions.
I think we have 3 more interventions. Senator Martin, Senator Deakin, and Senator Hanget.
To what Senator Ranget was asking, but I know that we'll have to create a seamless system. So with this new system, as it rolls out, you say you're using all the tools, but do you have the tools and resources to step in quickly if you see emerging problems?
Well, we have the tools, but we need more tools. So, for example, some of the recommendations, and I'll be sharing this with this committee in writing, but we called on having more privacy impact assessments, having faster notifications to my office, allowing more cross-regulatory collaboration, having stronger enforcement powers that are going to focus the mind. So we can have more tools, certainly. We're using the tools that we have now, working collaboratively, identifying the issues, prioritizing the issues, and using those opportunities. We were talking about data stored in other countries. We recently issued a decision on TikTok with my colleagues in Quebec, Alberta, and BC. And we specifically pointed out that this data is held in China. Canadians may not know that. So the policies at TikTok have to be more explicit. They have to make it easy to understand, easy to know, so Canadians can make those choices.
Thank you very much. Back to the Bureau. You've noted a concern that I've shared for quite a while. A single technical standard for sharing information, a single API, may limit our flexibility, especially when that API is governed by an American body and we don't know whether or not it'll suit our needs in Canada. So what is your advice to our committee? We've asked the Department of Finance on this, but what's your advice to our committee on this, on the risks associated with having a single standard, especially one that is governed from outside of Canada?
As far as we understand, this legislation doesn't actually pick a standard, but it does pick, it sets out a framework that the minister can use to designate a technical standards body. And if you look at the factors that are laid out there, Senator, it includes whether the body is incorporated, formed, or otherwise organized in Canada. It includes the independence of the body in exercising its powers and performing its duties. And it requires this body to operate in a manner that's consistent with the purposes of the Act, which the purposes of the Act talk about fostering competition. So the ingredients are there in terms of the factors that the minister can consider in going forward with standards. So we just want to see that those are carried out.
I concur. Thank you.
Yeah.
Compléter notre deuxième ronde et cette séance,
So
sénatrice.
to wrap up the second round, Senator Reingat.
This is setting up a new system, and as the Competition Bureau has stated, it's very important that consumers have confidence in the system in order to use it, okay? And within the scope of C-15 and within the means of this committee and the Senate as a whole, we can make amendments that do not entertain additional funds, taxpayer money. That's within our legitimate scope. So, to you, Monsieur Dufresne, in regards to penalties and other necessary aspects to make this new system work, please could you provide us with all the elements that is needed in this framework so that it will bring the most consumer confidence in this new system? Can you do that fairly quickly?
So I will send to the committee, we have made a number of key priority recommendations for overall privacy law reform. So I'll be sending that to the committee. That includes this enforcement power. I see this as residing more in an overall privacy law reform than in this bill, but you will see the general orientations and the general concerns.
We can act in regards to the scope of this bill. Whatever you send us that is not within the scope of this bill can be part of recommendations. Thank you.
Colleagues, and thank you for our witnesses. I just want to share with you colleagues and the Canadians who watch us that this is a very important file, and you have the support of all the Senate members here around the table. And I want to share as well that we have some external support here, because the Bank of Canada Deputy Governor has mentioned recently that she hoped that we will have more competition across the banking sector. So this is a public statement made in early October this year. So we have the support not only of the Senate members of the Banking Committee, but even the Deputy Governor of Bank of Canada. It's important. And thank you for your open mind that maybe to help us. I think when it's a pre-study, it's more observation because we cannot really amend. But I think that at some point we could influence even more the government. It's probably easier for them to amend a bill when it's a pre-study than after it's a day. So we'll see. I'm optimistic by nature.